coming to you from Los Angeles, California, and we're talking about guardianship matters, particularly the guardianship of Robert Johnson out of Newark, New Jersey, and the court case is CP 01362009, Judge Walter J. Koprowski, Jr., presiding over the case. The subject of today's message is, why did they lie to the court? This is about a guardianship case in New Jersey. The state-appointed guardian is Vanessa D. Johnson Taylor of Manalapan, New Jersey. Taylor claims to be the owner of the Taylor Group Incorporated out of Manalapan. Taylor also claims to be a real estate agent. In court papers filed November 16, 2011, Taylor claimed that she was attaching two appraisals to her complaint to sell the property of the ward. She is trying to sell a $190,000 rental property to attorney Savio Figaro, who is represented by broker Marlin Lakes Realty. Taylor's statement under penalty of perjury was signed and verified by her attorney Shonda Navarro Floyd. Attorney James Boutelier, also under oath, attorney for the ward, represented also that there were two appraisals being attached to the complaint. But did Taylor attach the two appraisals? No. The first document attached is an appraisal, but the second document is a market analysis and clearly says it is not an appraisal and not to be used for purposes of appraisal. So why did Taylor, Floyd, and Boutelier lie under oath to the court? So the judge ordered Taylor to present a second appraisal since the rule requires two appraisals, not one. On December 31st, 2010, Taylor presents an affidavit, again sworn under oath and signed by her attorney, also under oath. She and her attorney state that she is attaching two appraisals. Again, this is the efforts of these officers of the court as well as the court-appointed guardian. These are their efforts to sell a $190,000 rental property, and of course do it in a legal manner, not illegal manner. So again, they are presenting these documents under oath, and again, are two appraisals attached? No, only one appraisal is attached. And the other one states it is a market analysis. Again, a market analysis is not an appraisal. So another set of lies. Then in her papers, she quotes the Fox-Breyer documents and the Latorica documents, and she again calls them both appraisals. But the Latorica papers are only a market analysis. Excuse me if I said the name incorrectly. Now, Taylor has also been charged with improperly inflating the cost of repairs to spin down the sale of the property. She's claiming, well, first she was claiming $32,000 in repairs, then the figure went up to $37,000, and then we find out a year later that there was a document a document dated over a year ago, which stated that the cost of repairs were $58,000, I'm sorry. But of course we don't know if that document actually was authored 1 year ago, or if it was just doctored to look like it was authored 1 year ago, because it wasn't produced 1 year ago. Taylor and others should face jail time for their lies to the court. The court has been asked to find Taylor, Floyd, Boutelier in contempt of court. And fraud, of course, is defined as the crime of cheating somebody, the crime of obtaining money or some other benefit by deliberate deception. Synonyms are deception, scam, con, swindle, racket, deceit, fake, counterfeit. And of course, the word perjury means telling lies under oath. The telling of a lie after having taken an oath to tell the truth. And Vanessa D. Taylor, James Boutelier, Shonda Floyd, they all presented affidavits. An affidavit is something that you're presenting under oath, and they all presented affidavits. James Boudelier presented his affidavit to the court stating that he was in support of the complaint, and that's the same complaint that did not have two appraisals attached. It's very important to have the two appraisals attached because it's a due process situation, and due process is supposed to be guaranteed by the Constitution of the United States. Perjury, usually in a court of law, it's a lie under oath, a lie told in a court of law by somebody who has taken an oath to tell the truth. So Mr. Boudelier took an oath to tell the truth. Shonda Floyd took an oath to tell the truth. Vanessa D. Taylor took an oath to tell the truth, and of course they went to court and presented papers that were not truthful. James Boudelier is from the law firm Brandley, Klepp, O'Connor, and Boutelier, 13 Smull Avenue, Smull Avenue, Caldwell, New Jersey. Phone number 973-226-0526. Now, Lawrence E. Meyerson, he was one of the architects. He's an attorney who was one of the architects of the original contract of sale, which the court threw out. The court threw it out. The appellate court threw it out, and basically told them that that sale of contract was void and moot, and that it had to be redone, that the guardian had to reapply for the sale of property because something was wrong with that first contract of sale. Now here comes Lawrence E. Meyerson. Lawrence E. Meyerson was one of the architects of that contract, and he's an attorney and also a part-time judge. And what do you think he has to say about the current complaint, the current contract, or excuse me, not contract, but proposed contract of sale? What do you think he has to say about those papers that I just mentioned to you that don't contain the two appraisals? What do you think Mr. Meyerson said? Well, Mr. Meyerson said in writing that he supports the complaint to sell the property. He doesn't care about the fact that there are not two appraisals. He's going to support it anyway. And to me, that's the extent of the corruption in New Jersey, that a lawyer, well, actually a couple of lawyers, and then Mr. Meyerson, who of course is a lawyer, and then the guardian, who is state appointed, and of course the judge, excuse me, they're all basically going to support the fact that there's not two appraisals there. I do admit that the judge did order the guardian to submit another appraisal. However, the guardian did submit an affidavit of about 7 or 8 pages where she did attempt to explain some of the other matters in more detail. However, the judge has only given next of kin about 6 days, 6 to 9 days to go over those papers, and of course there's absolutely almost no documentation to back up the statements that the guardian is making. And of course this is the same guardian who's already admitted to fraud, committed continued fraud, and of course committed fraud in presenting the papers to the court. This guardian is supposed to be a real estate agent, so maybe she's never been a guardian before, but she's supposedly been a real estate agent for a number of years, supposedly has had a business, a home business for a number of years. So this is a person who would be knowledgeable and would understand the difference between an appraisal and something that is not an appraisal. I'm going to read now from some of the opposition papers to the sale of property, and also the response papers. This is all objecting to the sale of property by Vanessa D. Taylor. I'm quoting from the papers now. The amount of damages, the amount of repairs alleged has varied from $32,000 to $58,000. In fact, Taylor does not mention that the $58,000 was previously alleged. The Guardian presents an alleged plumbing proposal for $37,473 that is dated August 2010, with no explanation of why this is being revealed over a year later. And of course this is after the next of kin repeatedly, almost on a monthly, sometimes a weekly basis, asked for documentation, asked for verification as to what was going on with the property. And of course Vanessa D. Taylor, James Boudelier, Shonda Floyd concealed this. This is called criminal concealment. There's no verification that's been provided that the proposed buyer of the property asked for a repair credit. This is fraud in that such credit was not approved by the intended beneficiaries, nor has Taylor addressed the harm to beneficiaries interested in the sale of the property. This is bad faith in that the repair credit reduction harms the amount of money potential to next of kin as an intended beneficiary of the contract of sale. And of course, it's alleged that this is going on all across America, where the courts and the attorneys are involved with spinning down the sale of properties in order to maximize the monies going to prospective buyers who sometimes turn out to be very well connected to the courts and to other attorneys. We're reading now from some of the opposition and also response papers against the sale of the property. The Guardian has not responded to the questions about the previous annual accounting report of January 31st, 2011, and the unaccounted for approximately $3,000. Now, maybe $3,000 doesn't sound like a lot of money, but think about it, over the course of 10 years, it turns out to be $30,000, and this is something that the court has apparently turned a blind eye to. So where is the unaccounted for $3,000 that Vanessa D. Taylor has conveniently put under the heading of miscellaneous? I don't think the IRS would allow you to put something under miscellaneous. Now, Mr. Boudelier testified that the outstanding amount owed to the nursing home was $17,000, but Vanessa D. Taylor claims the amount is $72,000, and this difference must be explained. And again, the La Torrica price of $97,000 is not an appraisal, and this document is not an appraisal. But of course, Vanessa D. Taylor has committed fraud on the court and perjured herself and committed contempt of court by alleging numerous times in her written papers to the court that this is an appraisal when it is nothing more than a market analysis. Again, we're talking about fraud, we're talking about perjury. Vanessa D. Johnson Taylor of the Taylor Group of Manalapan, New Jersey, and the guardianship case of Robert Johnson out of Essex County, New Jersey, and this is case number CP 0136-2009. And we're definitely trying to keep the public advised as to the misuse of federal and state monies in the state of New Jersey by officers of the court and by the judge and judges themselves, who have unfairly treated litigants, beneficiaries of different estates. The 203K HUD loan worksheet states in this case that $9,000 is needed to replace appliances in 4 different apartments. Now, I've seen estimates in other instances where to replace a refrigerator, a stove, I don't know, whatever else goes into a kitchen, a dishwasher, can amount to maybe $500, including an air conditioning. Okay, let's just say $600. So $600 times 4 units is about $2,400. So it definitely doesn't come to $9,000, especially in this case, where the proposed buyer has said that they were going to do the bulk of the repairs themselves, or do all the repairs themselves. So again, this is something to look at and something to think about. And I thank you today for listening. Today is January 10th, 2012.